notes. Now, oh, guys, come on. Who wants to say? You all want to say a few words? No, Nadia's like, no.
We've got a few words, just a few words.
Sure. Okay. All right. Hi, everyone. You ready? Okay. Well, it's a pretty historic day for Queensland and a historic day for victims of domestic and family violence. I'm thrilled to be joined here today by Sue and Lloyd Clark and some of the tremendous women from the domestic and family violence sector today. I have just introduced a bill into Parliament that will further protect women who are experiencing coercive control. As a government, we have listened to survivors, we have heard them, we have believed them, and now we're acting. Today marks the first significant step. It really sets the scene for the introduction of a criminal offence of coercive control next year. This bill will significantly improve the protections for women experiencing coercive control. It amends the definition of domestic and family violence, importantly, to include a pattern of behaviour. Our system right now is really set up to respond to individual instances of physical violence. But we know that for so many victims of domestic and family violence, it's a pattern of controlling behaviour that happens over time. It can often be non-physical, but it can tragically have very serious consequences for the victim. It's not just about changing definitions, of course. It's really the first step in making sure that our system is far more responsive at putting women at the centre. We are also modernising the offence of unlawful stalking, including broadening the term of the offence to include humiliation, intimidation and abuse. The Women's Safety and Justice Task Force found that offence was hugely underutilised by police right now, particularly in domestic and family violence relationships, and it wasn't capturing the kind of abuse that victims suffer when it comes to technology. We know that perpetrators use invasive technology to track their victims, where they go, who they see, even restricting the amount of money they can spend. Our laws need to keep pace with the kind of technology that perpetrators are using to stalk their victims. And with 3 in 4 young people in this country having experienced some form of online abuse, it's important that our laws are contemporary and better reflect what's happening. We're also, of course, modernising some very outdated language in our criminal code, including the term carnal knowledge and including the offence of maintaining a relationship with a child. We have heard from victim survivors, like Grace Tame, that somehow calling what happened to her a relationship, of course, is incredibly offensive. We will now be changing that offence to repeated sexual conduct with a child, and I think absolutely better reflects the abhorrent behaviour by perpetrators who commit those acts. This is an historic day. It is a huge day for victims of domestic and family violence. This would not be possible without the advocacy of all of these amazing people standing behind me. I'm going to let them make a few comments and then I'm happy to take your questions.
I'd just first like to say that these are just small steps towards the government recognising these controlling behaviours of coercive and physical, psychological abuse, and that they're recognising these and that when the final law does come in, it should be a bit more airtight and we'll be able to make the perpetrator stand up and be recognised and make them accountable.
I'd just like to add that personally I feel the amendments to the stalking laws would have helped Hannah invaluably. So I think it's great. Thank you.
Hello, I'm Amy Carrington. I'm the CEO of the Domestic Violence Action Centre and the co-convener for Ending Violence Against Women Queensland. The amendments to the legislation today are the cornerstone for understanding that domestic and family violence is actually a context of pattern-based behaviour, and it is not just single incident based. moving away from incident-based responses is a really important part of our change in Queensland to get our responses right. It's also really important to understand that we need to have a considered and a holistic approach to legislating against coercive control. Coercive control is a very complex issue that needs deep consideration and collaboration. And I'm really confident today that government have heard these calls. And I'm hopeful that the voices of the sector, of survivors and our First Nations people will be a part of the solution as we move forward together to understand coercive control and to better respond to the needs and the safety for victims and survivors in Queensland. We welcome changes today, such as the definition of stalking to be updated to reflect the use of modern technology. Because I can tell you, in the service that we work, we're seeing technology-facilitated abuse every day. It is really crucial to address the unintended consequences of any legislative change as it comes through. And working together with our First Nations people, survivors, and also the sector is going to be essential to doing that on our journey moving forward. Ending Violence Against Women Queensland are asking our government to mandate training for all justice systems professionals, including magistrates and police. And we want this training to be evidence-based and provided for by our domestic and family violence specialist sector. We thank the government for their commitment to increase the investment and to work together within the community and the specialist services as we start to address coercive control in Queensland.
Hi, my name's Beck O'Connor and I'm the CEO of DV Connect. So we support the bill and the intention behind this bill as it will strengthen understandings of coercive control and ultimately strengthen responses which we know are an absolute breach of human rights and of self-determination. So we are heartened that the recommendations made by the Women's Safety Justice Task Force have been taken on board, and specifically that the changes will only be made once training has been rolled out and unintended consequences have been mitigated against. Family violence response services have been responding to coercive control and the devastating impacts of this behaviour for decades. We want to see this taken seriously within courts and police responses, and we're committing to holding the government to account to make sure the changes with legislation are adequately resourced. It's with sadness that DV Connect responds to families who've been impacted by the devastating impacts of coercive control every day. Strengthening of legislative responses is something that we hope to see translate to appropriate accountability measures for people who choose to use this behaviour within their relationships. Without challenging these behaviours and without holding people to account, legislation will not be effective in enacting change. Thanks.
Okay, happy to take questions.
Attorney, why not wait until the findings come out from the Commission of Inquiry before announcing or determining the coercive control, especially given the shocking evidence we've heard about police officers misidentifying First Nations women as perpetrators?
Look, absolutely. I think we can all agree that there have been some appalling and shocking reports from the Commission of Inquiry into how police handle domestic and family violence. But these changes today are really laying the foundation for the work that has to happen before there is a criminal offence of coercive control. The Women's Safety and Justice Task Force was incredibly clear. These amendments to legislation, like updating and modernising unlawful stalking, are needed now to better protect women and hold perpetrators to account. But there is a lot of work to do within the community, within our courts, within police, so that we can respond effectively to coercive control when it's a crime and that there are less unintended consequences. I think, with the advocacy from Sue and Lloyd and many others, we are now beginning to understand as a community how dangerous these controlling behaviours can be. Women are now coming forward for the first time who didn't think they were in a domestic violence relationship. So this is just the first step, and there is, I acknowledge, still a lot of work to do before we get to criminalising coercive control.
Do you have faith that the police will be able to lay these kinds of charges appropriately, especially with what we've seen with them misidentifying First Nations women as perpetrators?
So we have heard a lot about particularly First Nations women being misidentified as perpetrators, and that's why in this bill there are very strong provisions around magistrates and police making sure that it is the person most in need of protection that is getting the benefit of a domestic violence order. So there are very key legislative changes in here to try and avert that from happening. When a matter comes to court, a magistrate will now, for the first time, get the full history of domestic violence offenders and also have to, in the same hearing, determine which person is in most need of protection when looking at the context of a relationship as a whole. So these provisions recommended by the task force, I think, will go some way to making sure that less victims are actually misidentified and having a DVO made against them.
Does this bring us in line with other states, or are we sort of pushing ahead now?
Again, I think we are pushing ahead, particularly with the changes to unlawful stalking, by very clearly in our definition of domestic and family violence having that pattern of abuse. That is Queensland leading the way. And again, these were the clear recommendations from the Women's Safety and Justice Task Force to ensure that the Queensland system is responding to all forms of domestic and family violence, because we know that this coercive control, even though it may not have any physical violence, can be just as tragic for victims.
Attorney General, in the explanatory notes, it mentions that getting the broad scope of a person's DV history, including orders from interstate and New Zealand. I guess, what do you have to speak to your counterparts in those states? How does that work?
So it's basically any information that police have about a perpetrator, and that sometimes means that they will have interstate or New Zealand or international criminal history. The police have to give all of that to the magistrate. So the person making the decision has all of the information that we have across our systems.
On the stalking changes, how is the system currently set up? And are we seeing a lot of offences going without punishment because the laws were archaic?
I think, as the task force identified, this was just an offence that was not used very often in a domestic violence setting. And also, from police we heard that they didn't feel that the laws could adequately capture the technology-facilitated abuse that we are seeing. So it used to be that someone might physically follow a victim around, and of course that still happens, but what is more and more common is that perpetrators are using sophisticated GPS tracking in victims' cars, in children's toys. The technology that they are using is incredibly sophisticated, and our laws, as you say, have not been able to keep pace. I think these laws will also have broader effects when it comes to cyberbullying and young people being harassed and intimidated online. So I'm very proud that we've taken the steps today to modernise the offence of unlawful stalking.
I have concerns about how police will be able to prove a pattern of behaviour.
So there will be extensive training rolled out for our first responders and our prosecutors and our service system more broadly about how best to hold perpetrators to account when it comes to a pattern of abuse. So I understand that some of that training has already started, but as the task force have said, part of the task that we now have ahead of us before we even introduce a criminal offence is the education in the community, but also the education for our system to be able to successfully prosecute. And that will come to how we actually demonstrate that there has been that pattern of behaviour.
And just to be...
Why did the government sign an agreement with STAR and came approved in 2016 that would have meant compensation, new or increased taxes and the ability to regulation?
There are very common financial agreements. We've seen them in every other jurisdiction. But what Mr Goddison found in his review of casinos was that if we make regulatory changes, which are clearly needed to strengthen our regulatory response to casinos, that should not trigger any compensation clauses under a financial agreement, and that's why we'll be legislating to ensure that doesn't happen, and other jurisdictions have done the same thing.
So was it a mistake to do that?
Well, look, it was very common at the time in a financial commitment agreement to have those clauses, but clearly, given we've seen the appalling behaviour of Star in this state, we want to make sure that by strengthening regulation, putting in place really important gambling harm measures, that they're not entitled to compensation. Mr Goddison made a very sensible recommendation about that, and that's what we're adopting.
How far along to expressly negate?
Yes. Expressly negate the changes that we are making as a result of Mr Goddison's inquiry to trigger compensation.
How far along are you on putting the actual policy orders to?
So that's why it's so important we get these urgent amendments through the Parliament, because obviously one of the recommendations from Mr Goddison at the end of a show cause process was that there may be an option for a special manager. It's not something that currently exists in our legislation. So once the bill passes, we'll have that option. We can then issue Star with a show cause notice.
Does the Police Commissioner need new powers, do you think, to sack road police?
Well, certainly the Police Commissioner has indicated she would like further powers to be able to deal with some of the shocking and appalling behaviour we've seen come out of the Commission of Inquiry. I am very interested to see what Judge Richards recommends in relation to that. She's a very experienced District Court judge. She has heard the evidence firsthand. So I don't want to preempt anything that will come out of the Commission of Inquiry, but certainly we support the Commissioner, and if there does need to be further powers, we'll absolutely look at it.
Just back on DV, for people who might not grasp what is going on, this is actually tightening of current legislation. There's no new offence that's present, right?
There's no new offence. So the task force, as I have said, made it clear that currently our current laws need to be strengthened. So we're amending the definition to include a pattern of behaviour. We're modernising unlawful stalking. We're making it clear that DV history can come before a magistrate when they're making important decisions to keep women safe, and we're modernising language. The new offence will be introduced next year, but it's so important that we do this first, so as you've heard from our services, there aren't unintended consequences.
What would your message be to people currently in the DV scenario who feel like they can't speak up, or can't get up?
My message is, even if there is no physical violence in your relationship, if you are intimidated and in fear because of controlling behaviour, what is happening to you is domestic and family violence. Please come forward, there is help available. And my message to men who are using controlling behaviours to instill fear in their partners is that that is domestic violence. And there is help available. Please ring DV Connect Men's Line. Please understand that your controlling behaviour is dangerous and you need to seek help.
The amendments that are put forward today, when do you expect them to actually be reaching the courtroom or on a charge sheet?
So the bill introduced today will now go to the Legal Affairs and Safety Committee to examine the bill. I'm hoping that report comes back before the end of the year. The bill will be debated in the last sitting week of the Parliament or early next year. So there will be some weeks, obviously, for the process to happen, and I'm sure stakeholders will want an opportunity to further contribute to the committee process. But today is an historic day with the introduction of the legislation.
Ms Clark mentioned that the strengthening of these stalking laws would have helped. And in your understanding of all these laws, I guess how do you think that would have helped?
Well, I think it's again about sending a clear message to women about what is happening to them is criminal behaviour. It's sending a clear message to police to make sure that they are appropriately charging. It's sending a clear message and helping our prosecutors to be able to more successfully prosecute, particularly recognising the technology facilitated abuse that we are now seeing. So by modernising our laws and keeping pace with the tactics that perpetrators are using, not only can we help better protect women, but we can hold those perpetrators to account. All right.
You were saying that these changes would have helped Hannah. Could you just tell us a little bit more about that and how you think it would?
Well, I think with the amendments to the stalking laws would have helped Hannah. He had, I think there was about 6 or 8 iPhones hidden around the house where he would listen to everything she did. He had one in the car watching where she went. So just that alone would have given her a bit of ammunition to add to having a stalking criminal offence put at him.
And that's the thing, it's when it gets to court, it gives the courts much greater power.
It certainly does. Unfortunately, we didn't get to court, but it would have been great to have that if we had gotten to court.
And what's your assessment on the changes proposed so far?
We're happy with them.
They're needed. Like Shannon said before, they are needed to strengthen and to make the new law, when it does come in, airtight, and that perpetrators are then held accountable for.
You're just waiting for the big one next year.
That will be.
We certainly
a
are.
great day. Yeah.
Has this been a long time coming?
Well,
It seems
not for
a long
us.
time coming, but in the reality of getting laws changed and things done, I don't think it has been. I think the government's certainly been moving on it, and we're very happy.
I mean, there has been a voice out there for, I think, since 2015 about coercive control. And unfortunately, it wasn't a common thing. We didn't know about it until it happened to us. So the line in the sand was drawn that day, and of course, with us starting a conversation, everyone else has joined in, which has been wonderful. But we still need these conversations to go on. We still need education out there for our up-and-coming people coming through, younger generation. They need to know about coercive control and what a healthy relationship is. And we need to educate adults as well.
And do you have any concerns about how these new laws would be used and implemented, policed, prosecuted?
I just hope the education comes through with the police to help them know how to implement these laws correctly.
100%.
Thank you.
Thank you.
Thank you.